Welcome to today's program titled Illinois Emerging Privacy Litigation, What 2025 Has in Store. At this time, all participants are in a listen-only mode. For those of you who are logged into the web presentation, you are encouraged to submit questions throughout the program by typing them into the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit for this webinar, a CLE attendance verification code will be read later in the presentation. Please write this code down as it will not be reread and is required on the CLE credit request form. During the presentation, you will see a slide with a QR code that you may scan to access and submit your request for CLE credit. You can also find a link to the form in the connection details email you received this morning. Copies of the webinar recording and materials will be distributed to all attendees in the days following the webinar. On the next slide, you will see a legal disclaimer. This presentation has been prepared by Seyfarth Shaw LLP for informational purposes only. The material discussed during this webinar should not be construed as legal advice or a legal opinion on any specific facts or circumstances. The content is intended for general information purposes only, and you are urged to consult a lawyer concerning your own situation and any specific legal questions you may have. At this time, I would like to turn it over to our first speaker for today's program, Ada Dolph. Ada, please go ahead.
Thank you. Thank you everyone for joining us. Paul and I have been working together and partnering together on BIPA and now GIPA cases for some time. So I'm a partner in the Chicago office. Paul is my colleague there. And we both have been, as I said, following BIPA from the beginning and now are following GIPA. I will turn it over. Well, let me cover a quick overview in terms of the agenda. First, we're going to talk just a little bit about the history of BIPA, which will set the stage, I think, for what we're seeing happen in the GIPA cases. We'll talk about the most recent developments in BIPA. Then we'll talk about the emergence of GIPA and what we've seen so far. It's still relatively early, but we can talk through what opinions we've seen and the impact that those have had. So I will now turn it over to Paul.
Great. Thank you, Ada, and welcome everyone. As Ada said, my name is Paul Yvonk, and I'm a class action attorney in Seyfarth Chicago office. Today I'm going to be discussing three key issues under the Illinois Biometric Information Privacy Act that we expect to take center stage in 2025. But before doing that, I wanted to provide a brief background on BIPA leading up to 2025, because some of the past decisions have paved the way for the critical issues that we're going to see play out this year. So on BIPA history, BIPA was enacted in 2008 and was the first and still only standalone biometric privacy law in the U.S. with a private right of action. BIPA was enacted following the bankruptcy of a company called Pay by Touch, which allowed shoppers to pay for goods and services using their finger scan that was linked to a credit card. As part of its assets, Pay by Touch listed its server as an asset, leaving thousands of customers left wondering what will become part of their biometric and financial data. That caused the Illinois legislature to act. At its core, BIPA restricts the capture, collection, storage, and dissemination of biometric information without first implementing a public policy and obtaining written consent from an individual. Failing to do so, as you can see, results in steep statutory damages of $1,000 for each negligent violation and $5,000 for each reckless or intentional violation. And we'll come back to the statutory damages. That's going to be one of those issues that we're going to be discussing that's at the forefront in 2025. So since its enactment in 2008, more than 1,500 BIPA class action lawsuits have been filed in Illinois, with an overwhelming majority of the lawsuits relating to employee time clocks and coming after the 2019 Rosenbach versus Six Flags decision, holding that a mere technical violation of the statute is enough for standing. And as you can see on the slide, following Rosenbach in 2019, there have been a flurry of threshold matter issues that have required the Illinois Supreme Court's guidance. These include, in 2022, McDonald versus Symphony, which held that the Illinois Workers' Compensation Act did not preempt BIPA claims stemming from a purported injury in the workplace. And then in 2023, we had four big decisions, the first being Timms versus Black Horse Carriers, which held that all claims under BIPA follow the general 5-year statute of limitation because the statute itself does not contain any shorter statute of limitation. Then we had Cofferin versus White Castle, which was one of probably the biggest decisions out of BIPA, which held that each scan or dissemination of biometric information is a separate violation under BIPA, and that is also something we're going to be touching on a little bit later. Next, we had Walton versus Roosevelt University, which followed Seventh Circuit authority holding that the Labor Management Relations Act preempts BIPA claims by individuals subject to a collective bargaining agreement that contains a broad management rights clause. And then finally, in late 2023, we had Mosby versus Ingalls Memorial Hospital, and that decision held that the capture and collection of biometric information of a healthcare worker, and not just a patient, can be exempt from BIPA's requirements. And to date, there's only been one trial, which was the Rogers versus BNSF railway case, where a jury returned a verdict in October of 2022 of $228 million for reckless or intentional violations of BIPA at $5,000 for each violation of the 45,600 truck drivers who passed through a BNSF intermodal facility in Illinois that had to use a finger scan to gain entry to the facility. That verdict was overturned by the federal court following the 2023 Cothran decision, which held that the damages under BIPA are discretionary, such that the jury should have been able to decide whether each reckless or intentional violation of BIPA could be less than the statutory limit of $5,000. That case ultimately settled for $75 million and received final approval last summer. So to date, BIPA class actions as a whole have paid out more than $1 billion. And so with all of that, we're going to turn to the first of three issues that we expect to see make its way to the reviewing courts in 2025. Next slide, please. So the first one is the state contractor exemption. And Section 25E of BIPA provides that nothing in this act shall be construed to apply to a contractor, subcontractor, or agent of a state agency or local unit of government when working for that state agency or local unit of government. To date, there's only been one Illinois appellate court decision that has addressed this exemption, and that is the Enriquez versus Navy Pier case. In that case, the defendant was a not-for-profit corporation that operated exclusively for Navy Pier in Chicago. So in affirming the dismissal of the plaintiff's complaint based on the state contractor exemption, the First District of the Illinois Appellate Court articulated that a private entity falls within the exemption if it is a state contractor of a unit of government and was working for that unit of government at the time it collected or disseminated the alleged biometric information. And there, the court reasoned that the defendant fell under this exemption because it was a contractor under the ordinary meaning of the Black's Law Dictionary, and it worked for that government entity that owned Navy Pier because it performed services exclusively under those contracts. And so despite the broad interpretation of the state contractor exemptions set forth in Enriquez, Illinois trial courts have been inconsistent in their application to the exemption. So for example, you can see on the slide, Circuit Court of Cook County in Miranda versus Texaco ruled on a motion to dismiss that the phrase "when working for" means during the same period of time that a plaintiff was working for the defendant, rather than while the defendant was actively working on fulfilling the government contract or while the plaintiff was working on that contract. And so the court there framed the issue as a temporal question that asked simply whether the plaintiff was working for the defendant during the time that the defendant had a government contract and was a state contractor or subcontractor, and such a question could be decided on a motion to dismiss. On the other hand, and more recent, other trial courts have ruled that discovery and an inquiry into the type of state contract, the amount of revenue that the contract or that the entity derives from that state contract may be necessary to determine the applicability of the BIPA state contractor exemption, such that any exemption would have to be reserved for summary judgment. There have been a few cases that have been trying to make their way up on interlocutory appeal, certified question through the appellate courts as of the last several months. Turning to the next slide. So the next exemption that we're going to be discussing is this healthcare exemption for time clocks. So BIPA also excludes, in quote, information captured from a patient in a healthcare setting or information collected, used, or stored for healthcare treatment, payment, or operations under the Federal Health Insurance Portability and Accountability Act of 1996. The key part there that we're going to discuss is that, information captured from patient in a healthcare setting or information collected. Because that is what happened in late 2023 when the Illinois Supreme Court held in Mosby versus Ingalls Memorial Hospital that alleged biometric information collected by a healthcare provider from its employees, in addition to that collected from patients, could fall within the scope of this healthcare exemption when the information is used for purposes relating to healthcare, treatment, payment, or operations, as those terms are defined by HIPAA. However, Mosby specifically concerned nurses using a medication dispensary system and its finger scan device to provide patient care, and not the more common fact pattern in which healthcare workers allege violations of BIPA when they are using a timekeeping system with a finger or hand scan device. And that is something that the Mosby decision was clear in stating, that it was not making a sweeping categorical exclusion of healthcare workers' biometric information. Since Mosby, Illinois courts have been split on whether the Illinois Supreme Court's ruling extends to time clocks. One view, for instance, has been that the exemption does not apply because HIPAA does not define healthcare operations to extend to a human resources department managing employee payroll or processing vacation time or sick days, while another has been that the exemption does apply because the provider is collecting and using the alleged biometric data to track employee time so that it can conduct healthcare operations and receive payment for healthcare in compliance with federal, state, and local regulations. So as a result, this split is all but certain to lead to further guidance by Illinois reviewing courts on the breadth and limits of BIPA's healthcare exemption. And turning to the next and final issue that we expect to see in 2025 is retroactivity of the damages amendment. So as you can see on the slide, the BIPA damages provision provides for, among other relief, $1,000 for each negligent violation and $5,000 for each reckless or intentional violation of the statute. And the word each is important because, as we previously discussed, the Illinois Supreme Court in Cothran ruled that a BIPA claim accrues each time that the biometric information is collected or disseminated, and not only on the first scan or first transmission. And so White Castle and others cautioned that this interpretation of the statute could potentially result in annihilative liability to the extent that it was read as endorsing a separate damages award for each scan or dissemination of biometric information. The Illinois Supreme Court emphasized that there is no language in the Act to suggest that a legislative intent to authorize an award that would result in such a financial destruction of businesses. And in light of those policy concerns, the Illinois Supreme Court urged in its decision the Illinois legislature to clarify its intent regarding the assessment of damages. Until then, however, the Cothran decision invited some plaintiffs bar to pursue a per-scan theory seeking, for example, a statutory damage for each time an employee scanned their finger or hand on the time clock. And if we move to the next slide, we'll see that in August of 2024, the state legislature heeded the Illinois Supreme Court's call in an effort that culminated on August 2nd, 2024, when Governor Pritzker signed into law Senate Bill 2979. That amended the BIPA damages provision to limit an aggrieved individual's damages to a single recovery. So in doing so, the statute was amended to include the subsections you see on the slide, B and C, under the damages provision. Subsection B of the damages provision provides that it limits the recovery to a single claim for any claims arising out of Section 15B of BIPA, which is where there's the same method or capture or collection of biometric information without providing written consent. And subsection C of the damage provision limits the recovery to a single recovery for the same type of dissemination, which would be a claim under Section 15D of the same biometric information. And while the Senate bill was working its way through the chambers most of last year, one question started to swirl around. What will this damages amendment mean for plaintiffs seeking this per-scan theory in cases that were filed before the amendment is signed into law? And based on our theme today, I think you can guess what that was, an inconsistency among the courts. So if we turn to the next slide, we saw this play out in November of last year perfectly. In Gregg versus Central Transport LLC, a court in the Northern District of Illinois Federal Court ruled that the revision applied retroactively from BIPA's original enactment. As the court explained in this decision, in Illinois, there's a presumption that statutory amendments are intended to change existing law, and under this presumption, courts must determine whether the change applies retroactively or only prospectively. However, the court further said that this presumption does not apply when the circumstances indicate that the legislature intended to only interpret or clarify the original act. Because the Illinois Supreme Court in Cothran had expressly invited the legislature to clarify its intent, the court in Gregg found that the revision was merely a clarification rather than a substantive change. And so as a result, the Gregg court treated the amendment as if it had been in place all along. And so moving to the next slide. So in contrast, just 2 weeks later after Gregg, the court in Schwartz versus Supply Network Inc., which was another Northern District decision, held that the amendment constituted a change and not a clarification and could not be applied retroactively. So while acknowledging that the legislature can explicitly indicate its intent to merely clarify the law in the statutory text, the court concluded that nothing in the text of the amendment indicates that it's merely clarifying BIPA. So with those issues, and we've had trial courts in Illinois reaching similar conclusions, this is absolutely going to be something that we're going to see make its way up to the reviewing courts in 2025. So with that, I'm going to turn it back over to Ada to discuss an older Illinois privacy law that has picked up momentum as of recent.
Right. Next slide, please. Yes, this is the next generation of BIPA. It has bigger teeth, and we can expect that the rulings in the BIPA cases will play a significant role and have already in these cases. So out of nowhere, it seemed, we started seeing these Genetic Information Privacy Act cases filed. As the name would suggest, the statute is very closely aligned to BIPA in its structure, in its statutory penalty provisions, except rather than 1,000 or 5,000, the minimum statutory damages under GIPA are $2,500 for every negligent violation and $15,000 per intentional violation, or actual damages, whichever is greater. As we have seen in the BIPA cases, the cases that are emerging here, there has not been any harm alleged other than the statutory violation. You can tell I'm part of the defense bar there. And that's interesting because these cases then have been splitting between the federal court, which requires some level of Article III harm, and the state courts, which the Illinois Supreme Court has ruled an aggrieved person under the statute can proceed in Illinois state courts. And as the name also suggests, it governs genetic information. Genetic information is a very broad definition, and we'll get to that in a minute. But another thing that's similar to BIPA, but I would say it's more striking in the GIPA context, is GIPA's reference to all kinds of federal laws for its definitions and interpretations. And those are being worked out, trying to be worked out by defendants on the motion to dismiss level, but it's clear some of those are going to have to go to fact discovery. Okay, so like BIPA, the similarities with BIPA, it contains no statute of limitations. There's not a material difference really between GIPA and BIPA, so our expectation is that the courts are going to apply the same 5-year statute of limitations. And there's also, similar language that could play a role in each violation or each question rather for genetic information constituting a violation. But these cases haven't gotten quite there yet, but my expectation is that it'll be handled similarly to the Cothran case after applying the amendment, which gives some discretion then to the awarding court or jury. The biggest difference is that under BIPA, if you get the employee's consent, you're halfway there. You still have, maybe there's a violation for a policy that wasn't promulgated or something like that, but consent is not a defense in the GIPA setting. There's a couple of kind of odd, I would say, defenses that are pulled from federal law, such as inadvertence, which is if the question is narrow and in response, the employee or person provides genetic information, that you can argue as a defendant that it was inadvertently disclosed. So you weren't seeking genetic information, but it just was given to you. So it's remarkable that that's the kind of level of detail we're going to be getting into in these cases in terms of how they came about and what questions were asked. Next slide, please. Okay, so as I said, it defines genetic information, much like biometric information, very broadly. It also, which is different than BIPA, it refers back to federal regulations. So any change in the regulations could definitely impact, trickle down to the definition of genetic information here, which is actually happening, as we've seen, at a different pace than we're used to. So the genetic information, and many defendants, including Paul and I, have litigated this issue, is whether a question about family medical history constitutes genetic information. And there's been a slight split in the courts, but for the most part, the courts are finding that family medical history, asking that type of question constitutes a request for genetic information and a violation of GIPA. There has been some discussion about, well, does the question have to be focused on a health condition that is only inheritable or, comes from your genetic makeup? And there is some judges that have said, well, if you ask about, somebody's broken arm or, something like that, your brother's broken arm, that's different than asking about your brother's history of diabetes. So there are some tiny differences that the courts have been finding, but for the most part, any question that's construed as asking about family medical history is going to fall under here, and the courts are allowing those to proceed. Next slide, please. Okay, so who's being targeted? Essentially, anyone who has any sort of medical examination of an employee. And in some instances, it's a conditional offer of employment that's made, and then it's a condition of employment that you pass through this examination. Those are the ones that are probably going to be litigated more because of all the fact questions. There are also, though, employers being sued that basically have one or two modest questions that don't impact employment. And the plaintiffs are alleging in those instances that those are violations. So what constitutes a violation? Essentially, all these complaints are relatively cookie cutter, and they say, when I talk to, and it's even been attributed to, for example, recruiting staff. When I talk to the recruiter, they ask me about my family medical history. From my perspective, those allegations are difficult to believe in light of GINA being in place for so long, which also has governed this, and really just how careful employers are not to delve into this type of information. When the lawsuit comes in, we're also seeing requests for medical records. So if you're an employer that has a third party that does your medical examinations, they're still going to come to you and ask you for that. And there will be a whole, as I'm sure, a line of case law developing between whether you as the employer directly asked for the information or whether you directed a third party independent contractor to solicit the information. And then there's debates obviously between those two. If there was no clear direction and it was still asked, you should be looking at your contracts and things like that between the two parties. Let's see. Okay, so the other issue is that in these requests for medical documents, just take care to take a look at them, because often they only go back 1 year. We're seeing that they're very sloppy. So, don't be over ambitious and provide them with more information than they've actually requested pre-litigation, because what's been happening is those complaints are getting more and more detailed and more difficult to get dismissed. Next slide, please. So as we were talking about, I would say it's 100% that the defendants, for the most part, have filed motions to dismiss right out of the gate on these cases. Challenging, is a question about family medical history actually genetic information? And the courts are finding there, for now, yes. There are also lots of theories about preemption. Some have been successful. One was ERISA, where the complaint specifically referenced a work wellness program, and that program was part of an ERISA plan and therefore preempted by ERISA. There's another case that they were challenging that as well, and the court said it didn't have enough confirmation that the wellness plan was part of an ERISA plan. We're also seeing, just recently, there was a Federal Motor Carrier Safety Act preemption made in front of Judge Shaw that was ruled unsuccessful, in part because he found that the complaint did not reference or make central to the complaint and the allegations any of the documents that were proffered to support preemption. In the ERISA context, judges are fairly used to seeing those plan documents, which is why that argument probably had a little bit more traction. But getting into all kinds of manuals and complicated preemption arguments, the courts are rejecting those. We can expect, just as with BIPA, a lot of focus on very specific phrases and language, because as we know, these are often not drafted, perfectly, and there's a lot of debate over what was intended by the legislature. So, for example, the GIPA provides that the question or the request for genetic information has to be a condition of employment. The plaintiffs are trying to pull those two things apart and just say the ask by itself. But there's going to have to be discovery into, or if you can somehow affirmatively argue it on a motion to dismiss, that medical information or that medical examination played no role or could play no role in the employment. So there's been some litigation around cases where the plaintiff asserted, I was asked the question, I didn't answer, but the court still found the question was asked, and that is enough. So that just the ask by itself gets you into a violation in these cases. There's been fewer GIPA filings than BIPA. I think BIPA is basically low-hanging fruit for employers that haven't yet complied with the policy and things like that. GIPA, as we're talking about this, requires a lot more fact discovery. And an argument we've been really focusing on is that each instance of being asked for family medical history is individualized. So we're not finding, forms and things requesting that information. The plaintiffs are having to rely on these oral discussions with various people involved in their onboarding. And from my perspective, that is not a class that is certifiable. Each person would have to be, inquired of regarding whatever representations or questions they say were made for them. But plaintiffs are still looking for sort of that consistent unifying form or question or practice to make sure that they can try to get these into a class action. I guess one other thing I would mention is that the components of this statute that indicate you must also comply with, for example, OSHA, are raising some interesting questions. For the most part, the judges are saying, if you can comply both with OSHA and with GIPA, we're going to allow it to proceed. But I do think there are definitely areas in which those two may overlap. We know OSHA has certain requirements, for example, with a respirator that involves a particular questionnaire, a particular fitting and that sort of thing. So OSHA typically doesn't have preemptive power, but these are the types of things that are going to need to be sorted out by the courts in the coming year or years. We'll probably be doing this GIPA presentation for a while. Paul, anything else you'd like to add?
I think real quick, I think what we're going to expect in GIPA compared to BIPA is there's going to be a little bit more streamlined in responding to the complaint, because In BIPA, we were held, in hold from 2019 to 23 because of statute of limitations, workers' comp, claim accrual. A lot of those decisions are going to carry over in that what we're seeing in GIPA, like statute of limitations. Because there's no specific limitation, it's going to be the general, just like in BIPA. So we're going to see a lot of carryover. But I think, as Ada said, we're going to see a lot more discovery. It's going to be more intensive to figure out, is there a class, is it certifiable, what's being asked, is it individualized? I think it's going to be a lot more focused on that side. So that's my take on it.
Okay, in the moment everyone has been waiting for, the CLE code. The CLE code is SS3627. That's SS as in Seyfarth Shaw 3627. And with that, thank you so much for joining us today. If you have any questions about GIPA and BIPA, you know where to go, and have a good rest of the day.